It's Halloween, October 31st, 2024, and welcome to this installment of the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday, Jean Lawler and I are delighted to host another cutting-edge program for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great programs. We ask you to contribute to a food bank if you like what you see. And so far, our audiences have been so very generous in contributing in honor of our great speakers. It's over $625,000 contributed so far in honor of our great speakers. And we thank both our speakers and our audience so very much for having been so generous over almost 5 years now. Today we have another great presentation from Angela Dunning. She's a partner at Cleary Gottlieb in Silicon Valley, and she'll be talking about generative AI, IP risks and opportunities. As an IP litigation partner at Cleary Gottlieb, Angela Dunning works with both AI developers and those implementing AI tools to navigate these risks in a fast-changing legal landscape. She will discuss both input and output risks, including the possibility of bias, errors, and hallucinations, as well as copyright, trademark, trade secret, and data protection concerns companies should be aware of in developing and deploying AI systems. She will also provide an update on the current status and trend lines of U.S. IP litigation directed to the training and use of AI tools, offering perspectives from the front lines of several major cases. Angela is counsel in many of those cases in the Northern District of California and elsewhere. Angela, we are absolutely delighted to have you. We know it's going to be not a trick at all. It'll be a total treat here on Halloween to hear what you have to say. Please tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so, and then your presentation. Angela Dunning, the floor is yours.
Well, thank you so much, Jeff, and thrilled to be here to support the excellent work at Will Work for Food. I'm here to support the Second Harvest Food Bank located right here in the Bay Area. It's a very affluent area, generally speaking, but there are so many folks who go without, and if we can help distribute food as the holidays are coming up upon us, it'll make a real difference in the lives of our community. So thank you for your support, and I'm thrilled to get this chance to do my small part.
Thank you.
So I'll launch right into this discussion, and then if there are folks with questions, I'm happy to entertain those in the time we have left. I am going to talk about a number of the concerns and risks that people are sorting through with respect to generative AI and the ever-changing, quicker than we can keep on top of it landscape here. But I always like to start with a discussion of some of the absolutely groundbreaking capabilities. I mean, we have seen just in the not quite 2 years since ChatGPT was introduced publicly in the fall of 2022, just an explosion of not only the use of the technology, but the capabilities. We've seen models get bigger, quicker, more accurate. We've seen models developed that can, not just create text or code, but extraordinary images and video. We have a proliferation of companies offering these capabilities and tools, and they are pretty staggering in terms of the opportunity that they provide to individuals, to businesses. I talk to companies and folks all the time. A doctor last week who said that Kaiser in the Bay Area is rolling out AI to help generate patient notes following meetings, which can save, even if it just saves 10 or 15 minutes per patient, can allow her to see and treat more patients. And she treats pediatric patients suffering from GI issues. I've talked to a developer of therapies for cancer just a couple months ago, who is using a large language model to develop his pitch materials. He doesn't have time to work up those materials for investors. He's too focused on trying to get the therapies he's working on through clinical trials, but with these tools, he can generate those reports and try to generate rounds of funding to help support that vital work. So it's really an extraordinary time, and it's not really a question anymore of whether companies are going to be using these technologies, but how they're going to do that most effectively and to the greatest contribution to their businesses and the services they can provide to their customers. So we have seen, everything from this image that we created using the image generator offered by OpenAI, DALL-E. We just simply prompted it to create a photo of a lychee-inspired spherical chair, and you see what comes up is a beautiful image of a product that could be made and sold. So these tools are being used for product ideation. You see an image I created using Midjourney's image generating platform. I came up with the prompt for an impressionist painting of foxes in Tokyo at sunset. To my knowledge, never been done before, but up comes a beautiful image that you could see being printed as a poster on your wall. We've also seen video that can be generated using Sora with just a text prompt. And I don't know if, there we go, a little bit of video working here. So with just the words on your screen there below, Sora can create just breathtaking video. And this is being deployed in so many different ways. And you see just a list on your screen there of all of the different areas in which it's being used. We're talking about discovering new chemical compounds and formulas for making building materials, design alternatives. Chatbots are huge. We're seeing just an explosion of use of virtual assistants because they offer a natural language interface. Wouldn't it be great to be able to talk to your chatbot and say, I'd really love to order a burger and fries with a medium strawberry shake. No, actually, let's make that a chocolate shake, and I don't need the fries, but can you add a salad? And then it can update your order in real time, tell you what it is, and charge your card. In 2024, retail consumers will spend over $142 billion via chatbots, up from just 2.8 billion in 2019. We're seeing an expectation that the chatbot market will grow just by leaps and bounds over the next couple of years. Salesforce recently found that 77% of customers are saying that chatbots will transform their expectations of companies in the next few years. But we're also seeing use of these tools, again, to translate text to speech, to translate conversations in multiple languages in real time, to develop therapies and diagnose disease, to solve complex problems like climate and traffic, and just address basic business problems like analyzing patterns, for instance, to identify risk in your business, or to identify non-compliance with policies or laws among employees, so that you can address those through policies or further training. It's an extraordinary time. And the data analytics capabilities are, of course, extraordinary and far exceed anything we've seen before. So along with those extraordinary capabilities come some significant concerns, and everybody is well aware of these. They're very present in the news. We've seen real concerns about use of the technology to create images or content that could be used for election interference. We've seen use of the technology to create songs that mimic the voices or sounds of other artists. We saw an overcorrection in one of the in one of the large language models, which when prompted to create Nazi era soldiers, imposed a multiracial overlay to that, which plainly is anti-factual and counterfactual and not reflective of history. So companies are trying to figure out how to address concerns about how their capabilities may be misused intentionally by others and how they may inadvertently introduce bias or inaccuracy. We've also seen a slew of lawsuits filed. These lawsuits are primarily centered in the Northern District of California, where I practice, as well as New York, and they fall into two camps. One is mostly news organizations or music publishers, content creators who have filed direct claims against specific AI developers, claiming that their platforms can generate and are generating copies of copyrighted articles or song lyrics that people typically are required to license to and pay to use. The cases that I'm working on are copyright class action lawsuits, mostly filed in the Northern District of California, where the claim doesn't center around any outputs. The claim is not that the large language model is creating a book that looks like the plaintiff's book. The claim is that the model should not have been trained on content that may include copyrighted works. And so these are very much underway, and we'll talk about that in a little more detail. So let's start with copyright, which is one of my areas of expertise. I've been practicing copyright and trademark, trade secrets, false advertising, and related litigation here in the Bay Area in California for 25 years. And it's never been a sexier time to be a copyright lawyer. We will first address the issue of who owns what comes out of an AI generated an AI generator. So there's a little case I litigated a few years ago against the crested macaque you see here in the screen, Naruto, who filed a copyright lawsuit against a human photographer and the self-publishing platform he used to publish these photographs that he procured in Indonesia, using a lead that the macaques then used to take monkey selfies. And the holding in that case was that the monkey lacked standing to pursue a copyright claim because they're not human. And from there, we have derived a principle that's pretty much been continuous and uninterrupted in US copyright case law, including at the Supreme Court level, that human authorship is required for copyright. So we knew at the time in 2016 that this would be extremely important for the context of AI, where what is being generated is being generated by a computer program instead of arguably by a human. And so the Copyright Office has to date maintained that outputs generated by humans, artists or other users, are not protectable by copyright because they lack a human author. And so the image you see at the top of your screen next to Naruto there is an image called a recent entrance into Paradise. It's by a well-known inventor, Stephen Thaler, who asked for copyright protection for this work, which he claimed was created autonomously and exclusively by an AI software that he had developed. The Copyright Office rejected that application for lack of human authorship. He appealed to the district court, which affirmed, and it is now on appeal at the circuit level, where I think it's widely expected to be affirmed again. That was a fairly easy case, again, because of the way he put in his application, that there was no human involvement. But the images you see below that are an image called Théâtre d'Opéra Spatial, which was made by an artist, Mr. Allen, who actually won an award at an art show in Colorado for his work. He started with an image he generated on Midjourney, but then substantially changed it and spent just an extraordinary amount of time to create the final work that he submitted. And the Copyright Office has rejected that as well. And he has just filed an appeal claiming that in fact there is human authorship. He's put in his creativity, his imagination, and an extraordinary amount of time and effort. We also, I'm just going to go back one. We also had an application for Rose Enigma, which is a interesting development in the sense that the artist there, Chris Kashtanova, began with a drawing they created and copyrighted. It's the pen drawing you see, which they then fed into Stable Diffusion as an image prompt and asked it to create with an extraordinary level of detail and specificity in the instructions, the more the colorful and more more detailed work on the right. Now the Copyright Office has just rejected that as well, despite a lengthy discussion of the human authorship that went into creating that, and despite the fact that there is really only one human author for this work. Excuse me. So the current state of play is that things you develop using generative AI tools are not subject to copyright. And that's really important to keep in mind because it will help. It's important to know when you're making plans about how your business or you should be using these tools. If the outputs you're creating are something that needs to be protected by copyright because it's going to be released publicly, and you don't want other people to be able to use it, then you need to be thoughtful about how you deploy these tools. The Copyright Office will register works that have been created in part using generative AI tools, but they will only give copyright registration for the composition and the overall arrangement, as well as the human-generated content. Any images generated by a tool are currently not subject to protection. Now that is, as I said, is pending before the courts, who will have the final word on that issue. But it's something to definitely keep in mind. If we flip over to the U.S. Patent and Trademark Office, we've gotten somewhat different guidance. The Patent Office has said that for inventions that are created using AI augmentation, they may still be subject to patent if, in fact, the human contribution is sufficient to demonstrate human inventorship. In that instance, a patent will issue to the human inventors, and AI cannot own a patent. And so it's a different calculus then. We know that AI is being widely used for purposes of ideation and helping to create what the office has now said may be ultimately patentable inventions, so long as you've got that human contribution. All right, let's move to infringement. So most of the litigation that's pending right now contains claims for copyright infringement. We could spend a whole hour on this topic alone, but copyright infringement is basically the exercise of one of the exclusive rights of copyright without permission. So the exclusive rights include reproduction of someone else's copyrighted work, preparation of a derivative work, that is, you make something that is substantially similar, public distribution or performance or display. And for a work of someone to be infringing, it has to be substantially similar in its protectable expression. Copyright protection does not extend to any ideas, to facts, to concepts, to savoir-faire, to scientific principles. The U.S. Constitution in allowing Congress to confer copyright for limited time, was careful to say that we want this to promote the progress of science and the useful arts. And that means, in combination with our First Amendment protections for free speech, that everyone needs to be able to build on ideas and facts, to discuss them, etc. And so we have these twin principles that copyright does not cover facts or ideas. Those have to remain in the public domain so that science and the arts can move forward. And then we also have an important concept of fair use, which says even when you have a copyright over your work, others may use your copyrighted protectable expression if what they are doing with that is commenting on it or criticizing it or using it to offer their own message or create something new and different. Again, we want the arts to be able to move forward. And we want all artists to be able to build on styles and ideas and works that came before. And the fair use issue, we'll talk about this a little bit more, is very much front and center in the current litigation over generative AI tools. It has not yet been decided, but it's widely understood that those cases will turn on fair use. At the last point here on this slide, context matters, I just think is a really important to emphasize. The image you see here on the screen is one I created using Midjourney's platform. And you can see in this image, a bottle that resembles a Coca-Cola bottle, and also an image of Snow White and the evil stepmother. Now, if a party attempted to create an image on a platform displaying copyrighted characters and artwork from Disney or anyone else to sell that in competition with Disney's own images, that may very well be an infringement of copyright and not permitted and provoke a lawsuit. But in this instance, if a health organization wanted to create an ad campaign around the concept that sugary sodas are today's poison apple, you could see how that may fall within a fair use, because it's both a criticism and a commentary and conveying a completely different message and serving a different purpose than the original work. And so we don't know, for any work coming out of a generative AI model, it may be substantially similar in protected expression, but unless and until deployed in a specific context, we can't assess whether that use may be fair or not. And so this is a fluid area of the law, which has applied and been used for a long time to make sure that the uses that people make of other people's work fall within the statutory definition of fair use as it's been interpreted in cases like Google v. Oracle or Authors Guild v. Google, where, for instance, Google made copies of millions of copyrighted books in full to create a search tool that would allow anyone to pull up snippets of a book or look for words or phrases within it. The court found that served a completely different purpose, and the whole books could not be accessed there, so it didn't usurp the market for the books themselves by reproducing them. It served a different function that was transformative and therefore fair. Similarly, in Google v. Oracle, Google was permitted to use thousands of lines of code that was owned by Oracle to create the Android platform, which was entirely new and would allow developers to build new programs. So it's a robust landscape of fair use jurisprudence, and it's being built upon as we speak. There are nearly 30 cases pending at this point. The first one on your screen there is worth noting, Thomson Reuters versus Ross Intelligence. As that one is headed to summary judgment argument soon, that case involves an allegation that Ross Intelligence copied Westlaw head notes to create an artificial intelligence powered tool that allows for better, faster case searching, according to the advertising. Whether those head notes are copyrightable content and whether this was a fair use remains to be decided in that case. And then we have down the line to the most recent case that was just filed this fall. We've got one of the cases pertains to the copying of music lyrics filed by the music publishers. That's the second one from the bottom on your left there, Concord Music Group versus Anthropic. It says Tennessee there, but it has now been moved to California. And then we have the third from the top on the left, Anderson versus Stability. That is the case challenging the image generators. And then a bunch of these cases are brought by book authors alleging their books were used to train various models. So all of these cases are pending. We will not have fair use decisions in most of these for some time, and they're likely to be appealed and to take many years to finally resolve. The claims involve, generally speaking, claims that works were used without authorization to train the models. A number of related claims have been dismissed, including claims for violation of the right of publicity. Various state law claims have been dismissed as preempted by the Copyright Act because they're really a restatement of a copyright claim. We also have a few claims that allege trademark or trade dress infringement based on the outputs that are coming out bearing some alleged trademark or trade dress of the folks who claimed their works were used to train. But most of these cases are really focused on that training piece, and then for the direct claims on allegations that outputs reproduce copyrighted articles or music lyrics. We've talked about the fair use factors, but I'll just reiterate the most important factors are, is the work being challenged serving a different purpose and character? Is it conveying a different message? Is it transformative? Or under factor 4, is it merely usurping the market for the original work by reproducing it? These are going to be the key issues that drive the question of whether the training of these models is fair. And I'll point out that to date, there really aren't any claims directed to those who are deploying tools developed by others. The lawsuits are against the developers. And of course, depending on how that turns out, if fair use is found with respect to training, then we would not expect to see a next wave of any kind of lawsuits against those using the tools. But many of the developers do have indemnification provisions that provide some protection to users in that case. I'll briefly touch on publicity rights and defamation. There's no federal right of publicity currently. There is a patchwork of state laws, and the right of publicity generally protects an individual's name, image, or likeness, but also their signature and voice, and is generally used to prevent someone from using a person's identity to falsely suggest that they've endorsed a product or a position, and in connection with the sale of a commercial product or a political message or something of the like. We have seen recently litigation, I should say regulation passed in Tennessee. It's called the Elvis Act, which prevents the development of platforms whose primary purpose is to mimic the voice of others. How that will be interpreted and applied remains to be seen. We also have some various state laws relating to banning deepfakes and proposals at the federal level. But right now, it is mostly state right of publicity claims, and there haven't been too many. In the case of concerns like Scarlett Johansson being worried about her voice being used or something sounding like her voice being used for ChatGPT chatbot, that was quickly taken down. Defamation is also an issue that has come up. Defamation is, of course, a statement that injures a third party's reputation, and it requires some level of intent, depending on whether the individual is a private person or a public figure, and it's got to be false. And when we're talking about generative AI tools and outputs, it should be widely understood at this point that those models can generate inaccurate information. They are a large language model is trained on an extraordinary array of data so that it can understand language and develop an algorithm that will enable it to generate coherent text in response to a prompt that is designed to, probabilistically recreate what one would expect the next words in that prompt to be. But it's based on a probability as opposed to any sort of judgment or thinking. And as a result, what comes out needs to be very carefully fact-checked. But if it is inaccurate, we have seen a lawsuit in which an individual claimed that he was defamed by what came out of a model. And so we may see more of these claims. Privacy considerations. This is a big one. So for those developing AI tools or those fine-tuning or further training publicly available tools that have been released on an open source basis, you really need to understand some of the restrictions. So one cannot use personal identifying information of their customers without their explicit permission. And the Federal Trade Commission has found that a general provision in the terms of service or privacy policy for a company that says that PII may be used to develop or improve products and services would not be sufficient to confer consent to use customer data and PII for purposes of training a generative AI model. And the FTC has brought enforcement actions on the basis that failing to inform customers and get their consent has been deceptive. They have not only sought significant multi-million-dollar fines, but they also have obtained consent decrees that require that any data products and algorithms developed using data that was not consented for use need to be destroyed. So this is something that companies need to be aware of. I have here on the screen some examples of simple language that can be used to obtain this consent. We have seen developers change their terms of service to make it clear that content may be used to develop AI models and to improve model performance. And when you're thinking about whose platforms or products you may want to use, it's important to investigate what the model does and is intended for, what its limitations are, what data is used to train that model, and to be putting these tools to the right purpose. There are significant concerns and restrictions depending on your state on whether you can use generative AI or AI in general to make hiring decisions or other HR decisions or credit decisions. These are areas in which you need to be very thoughtful. And when entering into contracts with vendors, pay attention to what the indemnification provisions are that are offered. If there are provisions around how long training data or prompt data is kept and when it must be deleted, and who owns the outputs, who owns the prompts, and who can access that information. This becomes important in protecting trade secrets, for instance, because we want to make sure, of course, that trade secret information, to the extent you are using AI to build or develop that, is not being released publicly or to others, such that it might undermine a claim that you've taken appropriate steps to keep it confidential. I'll briefly touch on antitrust and securities. So in the context of the question whether use of AI tools to set prices could constitute an antitrust violation on the basis that it is collusive or unfair, the Department of Justice, with support from the Federal Trade Commission, has taken the position that this may very well be a violation. You can imagine two different companies, competitors, using the same AI tool to set prices, which then converge, even if those companies haven't specifically had a discussion about, colluding to set prices. And so this is another area in which to be very careful because of this risk of, claims of anti-competitive conduct.
Excuse me, Angela, let me ask, how is that different than people simply using the same mathematical or economic formulas on a blackboard with chalk?
Yeah, so I mean, to give you I'll modify your hypothetical. Two gas stations across the street from each other can see what prices they're posting and are free to update their prices or lower them to compete. I don't know that your specific question has been assessed, because for price setting, you do need collusive activity. But if there is a wink and a nod or knowledge that competitors are using the same algorithm to set those prices, the FTC has basically said that there could be this understanding that has developed, even if it's implicit, and that may suffice to show. I think that general formulas are free for everyone to use, but so long as you don't confer on which formulas you're using, so that everybody can make sure they're using the same one. In the context of SEC enforcement and securities litigation, we are also seeing activity. So we have seen, of course, corporate investment in generative AI tools wildly increase just over, in AI in general, wildly increase over the last 10 years. And we now have, as of last year, and this number will be much higher for 2024, over 40% of S&P 500 companies referencing their use of AI in their annual reports. Why is this important? Because the SEC is paying close attention to whether companies are overstating or AI washing, overstating how they're using these tools, the benefits they confer, and in that way, deceiving or misleading investors. So we have seen the SEC file enforcement proceedings and settle charges with at least 2 companies for making false and misleading statements about their AI capabilities, exaggerating what they were using and what those tools were doing for customers. And the SEC is plainly paying close attention to this. The SEC believes that investors think that the company's description of the technology they're using, and in particular their use of AI, is material to their investment decision. And so it needs to be accurate and not misleading. We've also seen private shareholder class action lawsuits filed with respect to AI-related disclosures. And again, the allegations are that companies have overstated the sophistication of their AI technology, how much they've invested, or what competitive advantages it has conferred on their business. And in at least 2 of these cases, the plaintiffs have gotten past a motion to dismiss that on the grounds that the statements were not false or misleading. And so this litigation is active, and as ever, companies should take care to make sure that the disclosures they make are true and not misleading to investors. I'll just briefly now touch on some emerging AI regulations. We won't have time to dive into this in detail because I do want to leave time for some questions if we have any. But there is a patchwork of AI regulations emerging around the world. We have in the US an executive order that was issued by President Biden about a year ago, instructing all of the agencies of the federal government to determine how to, I'll just go to the next slide so we can do this, to determine how to make the best use of the technology while protecting privacy, making sure that consumers and patients and other, American interests are safeguarded, to make sure that the technology doesn't get into the hands of foreign governments or illegal actors who would use it to harm our national security interests, for instance, that it's not being used in the context of, development of new weapons or other systems of harm. And to make sure that we are deploying these tools where we can to advance equity and civil rights. And that's one of the areas for a lawyer that is most exciting, because we really are seeing the potential to provide greater access to justice and a leveling of the playing field among the wealthy and the not as well off when it comes to litigation and criminal defense. We also have the EU AI Act, which is the furthest along. It has now come into effect, or is in the process of coming into effect. And the basic premise of the AI Act is that there are certain areas where we do not want to be using these tools, such as assessing, human worth or credit viability. We do not want it to be used for nuclear weapons or other areas that are so sensitive that they should be completely off limits. Then there are a set of high risk uses that are going to be subject to various rules and obligations. And then finally, for GPAI, or general purpose AI systems, which are not well defined, but that would be general large language models or image models that can be put to a wide variety of purposes, like those we've been discussing. There are a series of requirements that are being rolled out that include disclosure obligations with respect to how they were trained, that require some testing processes to make sure they're safe, and otherwise some training and other copyright compliance obligations. How all of this will be interpreted remains to be seen. I think one of the areas that I think a lot about and that keeps me up at night is the prospect for real conflict between the EU AI Act and its requirement that copyright holders be provided a means of opting out of having their content trained on. There's a real potential for conflict with that rule and US law, which requires and that fair uses be permitted. And if there is a finding in the US litigation that use of copyrighted content to train models constitutes fair use, but the EU law, which purports to apply not just to EU companies, but to any company no matter where they train their model or use their model, that are generating AI outputs that find their way into the EU, which is to say every one of them, that how do we resolve that? In the US, we say this is permissible under our law, and in the EU, they say it is not. There are international treaties and conventions that require respect for international law, and how that will be harmonized is going to be a big focus, I think, over the coming years. And so with that, I will pause and would be happy to answer any questions that folks have.
Angela, this was quite a tour de force, whirlwind tour of everything going on in the world of AI and litigation and disputes, as well as technical development. So thank you very much. We have a lot of mediators on the line. Let me ask you, when and where are we likely to see these cases come up for negotiated settlements? Which of these areas is perhaps most ripe for it? And what do you think these settlements are going to look like?
Yeah, so Jeff, that's a huge question. I'm so glad you asked it. So I think it's really going to be case specific. I don't represent anyone in connection, for instance, with the case that the New York Times or the cases that New York Times or Reuters have filed against OpenAI. But in those cases, you have news organizations who control and own a vast array of content. Suing the platform for allegedly being able to generate content in response to prompts that reproduces the copyrighted articles. Now there is there's a licensing regime in place when we get our subscription to whatever news publication we use, and it may be that those discussions are underway, but we are seeing some access or license agreements being entered with respect to content for training going forward, because companies are trying to avoid litigation risk, and also there's content that can't be accessed publicly that you need a access right to obtain, and in a manner that's curated and formatted for ready use for training. So it may be that some of these cases can be resolved through settlements that include some sort of agreement for rights to use that content. I think it'd be very difficult to imagine a scenario, and maybe this is just because I come at this from the perspective of a fair use proponent and defense attorney, but I think it's very difficult at this point to imagine any court finding that these tools have to be removed from the market or that people can't use them. Millions and millions of businesses are using these tools right now, and they are generating so many benefits for society, and at the same time that there are real concerns around the biased outputs, the prospect for bias in the training data, the prospect of hallucinations and misuse. The benefits are extraordinary, and this is why so many companies are deploying these tools to help with everything from marketing to product ideation, etc. So that's going to be an interesting challenge, how to craft in the cases that can be settled terms that allow the platforms to continue to be developed and used while addressing the concerns, particularly where, and this is such an important point, no piece of training data is in and of itself valuable. When I ask a large language model to tell me what the capital of Finland is, and it returns the answer, it is able to do that because of everything it was trained on, which, by the way, in almost every case, will have nothing whatsoever to do with the question I've posed. And so how you develop any kind of system for assigning a value to any particular training data, given any particular output, I don't see how that is feasible. I will just say this. So in the image cases where I represent one of the defendants, the allegation is that the various image models were trained on upwards of 5 billion images obtained through a general scrape of the internet. And statutory damages, if liability were to be found, are under the Copyright Act a minimum of $200 per work, even for innocent infringement, which if you do the math and assume there are even just, we'll call it a billion copyrighted images in the training, you multiply that by 200 and we are, higher than any of us should be counting.
That's more insurance than anybody has, huh?
And statutory damages for willful infringement go up to $150,000 per work, in which case we are in the trillions and beyond. So the amounts at issue are extraordinarily high, so high that they are existential. And in the books cases, we're talking about hundreds of thousands of books. So these cases have very high dollar figures attached to them, which is going to present challenges in terms of figuring out how to bridge gaps between the defendants who plainly believe that their training of these tools is fair, and the plaintiff authors whose complaints often boil down to not again that something is coming out of the model that looks like my book or my work, but that I just have this general feeling that it was not right for you to train on my work, and you should have gotten my permission and paid me for that. So I think there's a lot of work for mediators to do in trying to figure out how these very different perspectives can be bridged in if a settlement path is possible. I see these cases being litigated through.
For a while. So for the mediators on the line, now that we've listened to this very informative webinar, what should we do next so that when eventually these cases are ready to be mediated and settled and some fortunate mediator gets the call and the question, are you able to handle these cases? What else should we do to make sure that we are fully prepared?
Yeah, another great question. So, I mean, I think as lawyers, we are all bound by the rules of professional responsibility to, meet a level of competence. And now that competence definitely requires some versatility and facility with the tools. So I think, we should there's a lot of news. It's too much for anyone to process. But knowing what's available and how it's being used, I think is something that folks should have. I think if you wanted to set yourself apart as a mediator, following the current trajectory of cases across the different areas in which, I've identified litigation activity, will show a level of interest. There are certainly no shortage of panels, discussions with respect to these issues. I think the overlay of the understanding the overlay of regulations as best you can becomes important, because companies are trying to figure out how to comply with those, and that's going to be important to tailoring any potential solution. And you have the easier cases, right? Some of the defamation, the privacy, the securities cases where traditional principles apply. Those I don't know that those cases are I would market those the same way I always have. The allegations that a company is misstating how it uses AI or the benefits that it's deriving, that case is going to be resolved in the same way that securities class actions have been litigated and resolved for a long time. I think it's but being able to speak the lingo and feel comfortable in discussing what the tools are that are out there and how they're being used will be a real asset.
And let me ask you one final question before we're out of time about your personal use of these AI tools. What do you find personally the most important or productive or significant use of these AI tools?
Yeah, so I don't I represent several companies, so I won't make a commercial endorsement of any, but I will say the commercially available large language models can be extraordinarily helpful. I have asked, you know, I've asked one model to let me know if there's another. I do trademark litigation. So is there a logo out there that looks like my client's? Yes, in fact, here's this logo from such and such company. They don't have a trademark registration. Tell me how are they similar and different? Oh, sure, I'll be happy to do that. And then it will list all the similarities and differences between the logo. Tell me all the trademark registrations that use a logo like this. Here's the list. Could you put that in a chart form for me? Sure, I'd be happy to do that. Now, can you draft the first part of a demand letter to such and such company asking them to not use that logo? Now, at every stage of this interaction, as a lawyer, I'm going to check what is coming out, right? I'm going to check the trademark registration. I'm going to go to the websites. You're going to verify this information. But I think this exercise can save time, and it can still be used to train up our younger associates, right? They still have to apply their judgment and oversight to this process, but it avoids the blank page. It gives you something to start with. And I also take the duty of loyalty to my clients and not overcharging them very seriously. I think we're all going to have to think about how to deploy these tools in service of those we represent. And if we do it right and carefully and thoughtfully, we can provide real value while still bringing to bear the judgment that our clients and they come to us for.
Fantastic and fascinating. Angela Dunning of Silicon Valley, Cleary Gottlieb, thank you so much for this fascinating state-of-the-art presentation. I know that I'll be contributing to the Second Harvest Food Bank of Silicon Valley in your honor, and I'm confident that many others on this line, if they're in a position to do so, will as well. The website is www.shfb.org. That's www.shfb.org. On behalf of Jean Lawler, Natalie Armstrong-Motan, and myself, Angela Dunning, thank you so very much for this terrific presentation. And with that, we are complete.
Thanks so much.